Most common problems to avoid in your cases, in your lemon law cases. Uh, a lot of times consumer trust the dealerships too much. You have a problem with your vehicle, you take it to them, you drop it off, you list the problems you've encountered, and you trust them to do the repairs, and you trust them to write up the report accordingly. Unfortunately, you are dealing with personnel who are highly skilled, and they are much more knowledgeable than you are about the California lemon law. In fact, a lot of these personnel, the service representatives, end up being witnesses in these cases against consumers such as yourself. So, before you even realize you have a lemon law case, they know you have a lemon law case. So, a lot of times they will purposefully omit your concerns and complaints. The way to go circumvent this problem is to make online appointments. If you make an online appointment, you can write up all the problems you have with the vehicle, you can submit it online, you can do a screenshot or print out the page. That way you have proof of all the problems about which you've complained. The other thing is when you go in to pick up the vehicle, make sure that the documentation indicates everything that you complained about and indicates the solutions that they have tried to apply to your vehicle. Again, if you complain about something and you show them the issue, the check engine light or something else, if it's not on the records or in the return documents, if it states that there was nothing wrong with it, there's nothing wrong with you confronting them and saying, well, I showed you the check engine light, so how come the paperwork doesn't state that the vehicle came in with the check engine light on, for example? This is something very basic that you can do to ensure that your case is documented. The other one, I guess it's more of a step back from the first issue that I explained, is you need to take the vehicle in to the dealerships for repairs. The lemon law statute states that if a vehicle is presented to the manufacturer several times for repairs and the manufacturer fails to repair the vehicle after a reasonable number of attempts, only then are you entitled to seek a refund. If you never take the vehicle in, or if you wait until the end of your lease and then take in the vehicle saying, well, for the last 3 years I've had this issue with this vehicle, that means that the problem was not serious enough for you to seek repairs of it, and that means you will not get a refund. Another important point is that the statute states that the manufacturer is entitled to take an offset, a charge, for the amount of miles that you have driven the vehicle prior to presenting it to them for the repairs the first time you present the vehicle to them. In other words, if you buy a car today and you drive it and it starts exhibiting a defect tomorrow, but you keep driving it for 6 months or a year and you accrue 10,000 miles on the odometer and then you take it in, that means they're going to charge you, they're going to withhold the equivalent of those 10,000 miles, a fee that's equivalent based on the formula that's in the lemon law statute. Had you taken in that same vehicle the following day after the purchase when the problem came up, then they would be charging you for 10 miles rather than 10,000 miles, and the difference is drastic. So pay attention to the problems, report the problems timely, do not delay taking the vehicle in for repairs. And when you do that, do so online so that you can document your concern. And when you pick up your vehicle, make sure that the problems are outlined accordingly and the solutions that they've tried are outlined accordingly. And this is the best thing you can do to document your case in case it does evolve into something that you wish to pursue down the road.